Well, it is Saturday and I am in the office. It's been a busy week for our law firm, as always, in Pennsylvania and New Jersey. Put out a blog article regarding sentencing enhancements in the DUI cases in Pennsylvania. And the article focused on a recent Supreme Court case in Pennsylvania regarding ARD. Now, ARD, as many of my readers and my watchers know, is a first-time offender program that is usually used for DUI. It's where a person can avoid a criminal conviction in exchange for completing a program, a diversion program, and basically you're on probation for a year. And if nothing happens in that year, the case is dismissed. In some cases, you can avoid a license suspension altogether, but in other cases, it's much less of a license suspension than a conviction. Now, with that said, the Shiflett case came out from the Supreme Court, and what that basically says is that ARD cannot be used as a first offense. Now, if you took prior to this decision, if you took ARD and had a second DUI, you faced a increased penalty because they treated that second DUI as your second DUI, even though you were never convicted of a first DUI because you had the diversion program, but they treated the ARD as basically a conviction for sentencing purposes. And this was the long-standing rule for years, for decades in Pennsylvania. And many people thought it was unfair because the judge or jury didn't find you guilty. But the argument is that you were given this diversion program and you accepted it, and therefore you basically admitted that you did something wrong. But the Supreme Court found that that in and of itself is not a conviction because, again, the judge did not find you guilty, the jury did not find you guilty. The Commonwealth, the prosecution did not establish guilt beyond a reasonable doubt, which is the standard in any criminal case. So the Supreme Court in this recent decision said that you can't use, they being the state, the Commonwealth in the case of Pennsylvania, cannot use ARD as a conviction. So it's a really big decision because DUI in Pennsylvania, it increases substantially for second or subsequent offenses. For instance, a second DUI in Pennsylvania can be as much as 90 days in jail if your BAC is of a certain level, and a third can be a year in jail in some cases. So it's a dramatic difference, and also a felony conviction. So it's a dramatic case. It can mean a lot for an individual who is on ARD and finds himself or herself with a second DUI charge. It's a case that your criminal defense lawyer must be aware of. It's a very important case for sentencing purposes. And it gives your attorney a lot more room in terms of the decision regarding advising you on what to do. Now, let's talk about when to go to trial, when not to go to trial. And usually a decision to go to trial is based on either the offer from the Commonwealth is something that just not attractive, or it's something that you would probably otherwise get, or flat out you just didn't do it, and that's always a decision that's between you and your lawyer. So again, people say, well, how can you defend a person who did something wrong? But again, it's about the Commonwealth, the prosecution establishing guilt beyond a reasonable doubt, and it's also weighing the factors whether or not there is a risk of going to trial, and we evaluate that risk based on sentencing guidelines and what the offer is, even though there's mandatory minimum sentencing in DUI cases. And for the most part, in my experience, people are usually receiving the mandatory minimum. So in a lot of cases, it does pay to go to trial or even file motions to suppress evidence because you're challenging the probable cause for the stop, or perhaps or the probable cause to arrest following field sobriety test. You're challenging those field sobriety tests, or possibly you're challenging the actual device used, or challenging the blood test. These are all factors that your attorney must use, but now they also must consider this recent Supreme Court case regarding sentencing. But if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, the website gambone.com. As always, a tremendous resource for you and your family. All of my books, my blogs, my videos are available there in one convenient format. I'm going to link in the article that I wrote on the Pennsylvania sentencing enhancements for DUI. I'm also going to link in the update, which features that article in addition to our other most popular content from the previous week. The update, as you know, goes out each and every Friday to all of our readers. At this point, it's almost 5,000 people that get our newsletter each and every Friday. We never miss a week. It is the weekend. I understand that people are traveling. It is very hot out. My son had a hockey game this morning, and now my kids are playing at the house. But it's been a hot a couple days, both in New Jersey and Pennsylvania. It's supposed to be hot all week. I think they're actually putting in heat advisories, so it must be getting pretty bad out there. But again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey. Finally, it is the weekend. Please enjoy it responsibly. If you are stopped for suspicion of DUI in Pennsylvania or DWI in New Jersey, do not refuse the chemical test. It will never help your criminal case. Be polite, be respectful to the officer, but make it clear you're not giving consent to search your property or your person. Do so in a respectful manner. Remember, just be aware that you just have to be respectful to the officer. It is a nervous situation. You're going to be stressed, but try to keep your wits about you. Never put your hands on the officer, even though warrantless searches are permissible in New Jersey and in Pennsylvania. Police need a warrant to search your vehicle. Never stop an officer if he or she is attempting to search your car. Make it clear, though, you're not giving consent, but if they want to search the car anyway, don't get in their way. Don't put your hands on the officer. Again, it will never help your criminal case. It would only lead to additional charges and would just make it more difficult for your attorney to advise you and also represent you in court, whether it be in New Jersey or Pennsylvania. So once again, have a great weekend and please enjoy it responsibly, and I'll talk to you all very soon.